Hey guys, Anthony Bandiero here, attorney, senior legal instructor, bringing you a roadside chat from an officer in Texas. Now, this officer says, asked basically, can we automatically pat down suspected gang members, right? And to give you a little context here, the officer is talking about, attending some outlaw motorcycle gang training and, get a lot of banditos in the area. And the instructor is basically saying, hey, look, if you are dealing with a one percenter, right? Michigan versus Long, which is a U.S. Supreme Court case about frisking vehicles, allows you to essentially, conduct a frisk of that motorcycle for weapons. The officer will first ask, this is what they teach, they'll ask for consent to search the motorcycle. If they say no, then they get them off the bike and they search it anyway because of it's known that gang members can easily access the saddlebag. These gang members can access the saddlebag and potentially grab a weapon. Now, the question is does Michigan versus Long really hold that suspected gang members, essentially can be automatically patted down just with that fact alone? And certainly Michigan versus Long is not that fact pattern. That case involved a drunk driver who crashed into a ditch, and the officer saw him trying to go back to the car, and there was a knife in the mat pocket in the door because the door was open. He got, Long back, and another partner seized the knife and looked for more weapons in the immediate area and found narcotics in the center console. And the Supreme Court upheld it because the logic was, hey, look, he was trying to go back to the vehicle. It's a fluid situation. He's intoxicated. There was already one weapon in there. There could potentially be another weapon in there. And that frisk of the vehicle is upheld, but it certainly didn't talk about anything about gang members. Now, all I can tell you is what I teach, right? I don't teach automatics, like, automatic searches, for my cops. There's really no automatics out there. There's no free lunch when it comes to the Fourth Amendment. You're going to have to work for it a little bit. You're going to have to go to court and explain that simply having a 1% patch, that's one factor. It's a very important factor. But what else do you got there? I mean, we're going to have something more. And usually there's going to be, so that's the good news. Here are some cases that kind of, illustrate what I'm talking about, right? Here's a case out of Kansas, a case called State versus Goldston, 2009. Now, it says here, at the time that the officer conducted the pat down, he knew the following facts about the suspect. He was in a database as a documented gang member. He was with a known gang member who was on supervised release from prison and had been involved in a prior stop involving drugs within the last 2 weeks. He had just come from a city known for drug activity and where several arrests or area of town. Actually, it's not a city, it was a gas station. He just came from a gas station where several arrests have been made recently for drug activities and so forth. The officer also articulated that he knew that drug dealers that involved in gangs often had weapons to protect the drugs and the money, right? They're self-help, right? They're like their own little police department. And considering all these facts, the court upheld it. But do you see what's going on there? It's not just saying, Your Honor, the person is a one percenter, therefore I conducted a vehicle sweep, or a pat down. We need something more than that in my book. But you're going to have it usually. Let's go over another case. This case is United States versus Hammond. It's out of the 10th Circuit, 2018. Police officers conducted a traffic stop at a busy intersection, right? They also believe they had reasonable suspicion that the passenger was armed and dangerous and patted him down for weapons. Why? Because they knew from a database search that he was recently arrested in connection with a weapons possession. He was previously being a suspect in another weapons case, and he was listed as a gang member. You see my point? There's usually something more going on. Now, you're the ones that are gonna have to make these decisions out there. I can't make them for you. But from a legal point of view, I just need cops to articulate why they're doing what they're doing. I have a class called Bulletproof report writing, and essentially what the class is all about is getting you guys to articulate more. The facts are there in 99% of these cases. The facts are there. These facts are there. These things that are going on, but we don't find them out until we go to a suppression hearing and we pull the facts out like we're pulling teeth. When in my book, we could have just documented those things in the report and not had the suppression hearing probably to begin with, because the officer would have been like, hey, look, these are all the reasons why I did a frisk and I pat this person down, not simply being a 1%er, even though that probably is the most important fact. But there's something else. What about his attitude? What about how long did he take to pull over, right? Who is he associating with? What is his prior history? Is he favoring one side? All these things. There's probably more there. All right. But again, you make the decision out there. It's your safety. I can't make that decision for you. We can only fight about these things in court. But I want you to be physically and legally safe. Okay. Before you guys exit and go on to the next YouTube video, do me a favor, hit like, comment, whatever you, good or bad, and tell your friends. Hopefully this is helping. All right. All right. I'll see you guys next time.
When it comes to law enforcement training, we are the gold standard. Visit bluetogold.com or call 888-579-7796 to learn more about our training, books, and free webinars. Also, don't forget to like, subscribe, and share this channel.